think a mediator can be as effective.
Our distinguished speaker today is Kendall Jones. Kendall is the General Counsel of California Pizza Kitchen, based in Costa Mesa, California. After graduating with honors from Vanderbilt Law School, Kendall started her law career as a litigator in Big Law in Atlanta in 1995. She went on to practice in firms of various sizes and as the head of her own law firm before she went in-house in 2017. Kendall is actively licensed and has practiced in California, Georgia, and Florida. After spending the first half of her career primarily as a litigator, Kendall broadened the scope of work she performed for her business clients at their request, which eased her transition to in-house counsel. Kendall has been with California Pizza Kitchen since August 2019 and has been its general counsel and corporate secretary since April 2022. You may also have seen Kendall on television. She's a card-carrying member of the Screen Actors Guild. So to talk about managing client expectations in mediation and litigation, Kendall, please tell us a little bit about the food bank to which you'd like people to contribute if they're in a position to do so. And if you can, we'd also like a barbecue chicken mediation, smoked Gouda, red onions, and a little extra cilantro.
Mm-hmm.
Kendall Jones, the floor is yours.
Thank you so much. The food bank that I'm actually personally involved with is the Mariners Food Bank every other Saturday in Huntington Beach, California. And they have a packed house every other Saturday. So I would love it if people can contribute to that. Thank you. And yes, pizza is a big part of my life. It has been for a while now. So much so that when I tell my kids, hey, I'm going to go pick up CPK for dinner, they groan and they go, oh no, not again. You know, they're so tired of it. But thanks so much for having me. As you mentioned, I've done all the things. I've worked for all different sizes of law firms and different sizes of clients with different temperaments and tolerances. And I've worked in 3 different states. So over the course of my 29 years. So one of the things that I have found to be a constant in all these years across all different levels of clients is the need to continuously manage client expectations. And so this is a really good topic for me to discuss. So one of the, I'll talk about what that means kind of in a minute, but I want to talk about the importance of it. I think that management of client expectations, unfortunately, is not something that's taught in law school, as we know. And it's not even the first several years of my practice. I worked in big law under many mentors and supervising attorneys, and they don't really teach it either. And some of them don't even model it. Some do, but you don't understand what you're seeing when you're a young attorney. You're just trying to learn about the process and what being a lawyer means, right? And so it's really something that you kind of have to develop over time, and not every lawyer does. And it's really important to artfully develop the ability to manage client expectations. And what I mean by that is by making sure your clients feel validated and educated without being insulted or feel like you're against them. And if you artfully develop those expectations of your clients, and we're going to talk about what that means, obviously, then you really do become a trusted counselor to them and not just their lawyer on this one case. And when you become a trusted counselor, they have faith in you. They'll come back to you for other things. Like you said in the intro, I developed a business practice outside of litigation because litigation clients trusted me as a lawyer, and they came back and said, hey, can you help us do this other? Can you help us develop this contract? Can you help us read this business plan? So you can broaden your skill set. You have return clients, and there'll also be referral clients that you get from that. So being somebody that can really be a trusted counselor is really important. And you're not going to do that if you can't manage your clients' expectations. So what does that mean? So when I talk about client expectations, typically we always think about financial expectations, right? We always think if it's a plaintiff, how big do they think their case is worth? What is the case valuation? If it's a defendant, how much are they really expecting to spend on the case? And what do they think they're going to get out of the money that they spend? but there's not just financial expectations, and we're going to talk about all of these, but I think another big expectation that people, that clients need to have managed is their expectation on the timeline. People don't understand even ADR is not something that's done in 6 weeks normally, maybe sometimes, but it can be a year or more before you actually go to the arbitration. Mediation, hopefully a little faster, but in litigation, cases last for years, and people don't really have an understanding of that. Also, expectations regarding the process. What happens next? I've had defense clients come into my office and say, I'm sure you're going to get this dismissed right away because it has no merit. And they need to understand that that's really not the way it normally works. I mean, maybe, but usually not. That's not usually the way it works. And so they need to have expectations sort of managed on finances, timeline, and process, and other things that come and go, but those are the key parts of management. The one thing I want to address before we talk about how and when those things get managed is something that I think is the 800-pound gorilla in the room on this issue, and that's what I refer to. And if we've practiced for longer than a couple of years, you've seen this. What I refer to as yes men lawyers. Lawyers who just are mouthpieces for their client, who are just repeating what they're saying, doing what they're demanding. We've all seen it. And when you do that, you're not serving your client well. You're not being an attorney. First of all, you're just being a parrot, right? But the problem with that, with client expectations, is I'm going to back up, and kind of the way I describe my job to a lot of people is my client comes in with at least one of, maybe the biggest problem that they're facing. And it's my job to take it off their shoulders and put it onto mine, while leaving the emotion and the subjectivity and the biases behind. They get to keep those because that's not my job. My job is to be objective and logical and view the problem from 10,000 feet, right? Look at the whole forest and not just one or two trees. And a yes man lawyer is taking the whole package on. They're taking on their client's subjectivities. They're taking on their client's expectations. And so if you are taking on the whole thing with the biases and expectations that come with it, you have no hope of managing those expectations because you're wearing them too. And so it's really important as an attorney to make sure your clients feel comfortable right from the beginning that you're taking on their problem, but you're going to be the grounded person of the two of you. You're not going to be the emotional one. And it's difficult to work with yes men attorneys on the other side of cases. It's happened a few times. I actually have an arbitration case right now where there's one, because not only are they not serving their clients well, because they're just mimicking everything the clients say and want and demand, but they're also making the whole process more difficult for everybody. If they're not expressing independent thought and guiding their clients' expectations, then the mediator or their arbitrator can't get very far. The judge gets very frustrated. Lots of, junk motions get filed. We have to spend lots of time and money dealing with junk motions or ranting emails. And I'll give you an example of the case I'm dealing with right now. Hopefully I'm not going to get in trouble for telling this, but we have a case, an arbitration matter right now. And the opposing party is somebody that I know. And his lawyer is literally, this guy, the party, is sending his lawyer these long ranting emails, and his lawyer's cutting and pasting them into emails that he sends to me. So he's not doing anything independently. And the emails are nonsensical. They're ranting, they're petty, they're focusing on a couple trees instead of the whole forest, and that doesn't help. That's not productive to our process. It doesn't help anything. And the attorney's not helping his client by saying, hey, wait a minute, this isn't what we should be focusing on. And it's frustrating. So that's my little soapbox for the day. I want to just address, I'm sure many of us have dealt with yes men lawyers, and that is the biggest block to being able to manage expectations of your clients, because if you're just doing what they want and say, you have no hope. You can't even begin to manage expectations. So let's talk about when that managing expectations starts. And it starts the first time you ever meet the clients. The first time when they call you and set up the appointment, that's not what I'm talking about. I'm talking about the first time you have a substantive consultation with them. Maybe they've sent you some documents, maybe giving you a little idea of what's happening on the phone. When you sit down with them on a video conference or in person, and they go through the facts and you're gathering information, that's the time right then to start managing your client's expectations. Because they come in with, often, like I said, it's their biggest problem that they're facing. They're very emotional. Even if they're CEOs of companies, they can still take these things very personally sometimes, and there are emotions that are involved. And you have to gauge where they are in the process. I'm going to give you a couple of examples. A plaintiff might come into your office and she slipped and fell on a piece of lettuce in the grocery store and sprained her ankle. Maybe the EMTs came, maybe she even went to the emergency room, but ultimately has no permanent damage. If she comes in thinking she's got $1 million case, and that happens all the time because of TV, then you have a big management of expectations problem on your hands. You got to start right then by saying, gosh, this isn't the kind of case where you're going to fund your kids' college educations. I'm just letting you know that this probably isn't $1 million case right then. And you can do it in a way that's very sympathetic and even empathetic. You just can't be like, yeah, let's go get them. Yeah, I'm going to get you $1 million. But that happens all the time. On the same time, like the defense side, I said, gave you the example of a defendant who comes in and says, this case is just complete BS. You should be able to dismiss it right away. That's also unreasonable. That doesn't happen. I mean, even if you do file a successful motion to dismiss the case, the chances are the judge is going to say, well, okay, but the plaintiff's got 30 days to amend to make it right. That happens more often than not. And so you just need to make sure you don't oversell or overpromise, especially if you've got a client who does have some unreasonable expectations coming in. And it's important that you don't overpromise or oversell, because at that first meeting, you don't know what you don't know, right? I mean, I've never had a case ever where the facts of the case as they develop are exactly as the clients described to me in the first meeting. There's always something else that comes out. And sometimes it's not in their best interest. Sometimes they didn't tell me because they didn't want me to know, or they think somehow I'd like them better if they didn't tell me. Sometimes they just don't know, right? So you can't make promises at that first meeting.
Kendall, I think I once read on a fortune cookie, a case never again looks as good as it does on the day the client first walks into your office.
100%, right?
So with respect to that, if you're a contingent fee plaintiff's lawyer, and I assume when you were in private practice, you represented some plaintiffs.
A couple.
How do you deal with the concern that if you don't pump the client up and tell them they're going to do fabulously in this case, that there's some other lawyer down the street who will tell the client that and will get the business instead? So what are some practical things that a lawyer can say to try to overcome that with a prospective plaintiff?
Well, you can't always, right? You can't always. There always will be a lawyer down the street who'll blow smoke up people's, backsides to get a case. And when that happens, nobody's going to be satisfied with that result. Nobody will be. The client won't be. The lawyer won't be. It will not be a satisfactory result, because we know it won't happen the way that they say or the way that the client wants. But I think the best way to do that, the one that I've done the most, is I've said, hey, you know what? Let's pull some cases that are like yours. Let's see what some results have come out that have been like your case. So instead of just taking my word for it, I now have empirical evidence that I can show them that cases in California, in Orange County, wherever we are, that are similar to this have been $25,000 to $40,000 cases. I think that helps a lot. And if they do decide that they have the exception to the rule and go down the street, that's just what they do. I think there have been a couple of cases. I didn't do this at the beginning of my career, but the last few years before I went in-house, I was willing to say no to a case because a client just was going to have incredibly unrealistic expectations that they were dug in on, they weren't going to be able to get away from. And I have to be willing to say no, because those clients are going to be impossible to work with. They're going to be impossible to satisfy. They're going to write a bad Yelp review. Even if we get a successful or appropriate resolution, they're not going to like it because it won't be enough. And I think one of the the negatives I've seen, I see a lot of lawyers who will go to mediation and rely on the mediator to play bad cop. I'm sure, Gene, you've seen that. And rely and tell the mediator, I need you to play bad cop because my client's not listening to me. Well, that just means you haven't been managing your client's expectations very well. That means you haven't been honest with them about the value of the case. You don't get to rely on the mediator to do your job for you. The mediator is there to facilitate a resolution, not to be the bad cop in the relationship. So I think that you have to be willing to let those go if you can't convince the client that they're wrong. You just have to, you know. You don't have to take, it's hard when you're a sole practitioner not to take every penny that walks in the door. It's really hard, but you have to because it's going to be a nightmare for you if you don't. And you realize that, I think, as you get a little older in your career, you know.
Yes. And then similarly, Kendall, you're in a position where you have one client, you work with one company. How do you balance the concerns about not being a yes person lawyer against the idea that, gosh, this is my boss, this is my one and only client.
Yep.
Can't deliver what they want. Maybe my job is security is on the line. Maybe there'd be other consequences for them.
Well, I'm fortunate that at this company that I work for, my client is the executive team and the board of directors, right? They are all experienced business people, have been doing this for a long time. They understand and appreciate a general counsel's role. I also have demonstrated to them that where there's a place for wiggle room, I'll find the wiggle room. Where there's not, I'll tell them truthfully that there's not. And I think because they see that I'm willing to be flexible where we can be, then they trust when I say we can't be. I think that developing that kind of relationship is really important. You have to really, when you're in-house, you have to really become a strategic business partner to the business people and not just the lawyer. And you can't be at my company, they say that most general counsel are called the deal killers or the sales killers. And I'm not. So my team's not anyway. So we take that as a big compliment, right? But I think that's how you strike that balance. They'll listen to you when you say this is what we have to do. If you say, let me figure out a way around that, or let me figure out a creative solution for that on the times when you don't have to put your foot down. I did have to have one sort of intervention with one business person in our company who was very dug into a position that just didn't have reasonable expectations about what was going to happen. And so I gathered a couple of other members of the executive team and we sat down and we said, here's the deal. We want you to understand. We appreciate that you feel very personally about this, but this is not a time to make a personal decision. This is a business decision and a financial decision, and we need you to come around to it. And it worked immediately because they just trusted us. But that's the most extreme thing I've had to do in-house. I hope that my boss isn't watching this. Okay, so one of the things I would talk about during that first meeting is to start laying the groundwork for the valuation. We're talking about the financial expectations now. During that first meeting, you may not know enough about the case to create a full case budget. You probably can, for defendants really like to see case budgets. It's hard, but if you've done it enough, you can probably develop a case budget and be conservative with it. And with the plaintiff, like I suggested, you pull some comparative cases so that just show them what the case is worth, to show them valuations. If they are asking for some crazy things for you to do right out of the box, like file a motion to like a motion for summary judgment or something, crazy, or, send them a demand letter and demand to, take their business. I think it's important you don't have to insult your clients and say, that's crazy. That's never going to happen, never going to work. But you can say, look, it would be so unusual for that to work. I don't think that's worth your time and money. I think that we can spend our time and money doing something that will let me put together some options for you. Maybe we send an early 998 offer to a demand, or maybe we, there are some things you can do to manage. They want something fast to happen. And there are some things you can do to make them satisfy that need for something fast without doing something that is going to be frivolous and maybe get you sanctioned. So there are ways to do that. Then I would talk about, I've got notes here I'm looking at. Then as for that first meeting, talk about the timeline. That's really important. Talk about the timeline. because when clients come into your office for that first meeting, they're often very energized and enthusiastic about their case. And a couple of years from now, the case is still going on, and you're still even in discovery, they're not going to be that enthusiastic anymore. They're going to be very frustrated, and they're probably going to blame you. And so it's really important to tell them ahead of time, here's what we can expect. And not just ahead of time, but I'm going to tell you, I have those conversations throughout the whole case. Every time I communicate with my clients, I'm communicating about what's going on, what to expect, everything. And then let's see, the last thing, okay, then I put in my notes to not be afraid to say no. So that's the first meeting is where you plant those seeds. It's actually not a bad idea if you represent the defendants to start maybe just mentioning that at some point you might want to talk about a settlement number, but it's too early now. Don't, but the word settlement should maybe come into the picture unless it is a slam dunk case, which I've not seen very many of in my life, right? So that's not a bad thing to just put on the table, plant the little seed during that first meeting. The next time I find that I have to have these conversations is after I write a brilliant piece of writing, a brilliant demand letter, a compelling complaint, a brilliant brief or a counterclaim. If you're a good writer, and a lot of us are, when your client reads that, man, they'll drink the Kool-Aid, right? They're like, you have sold me on my case. I did not realize our case was this good. And now we're all in, right? And so you immediately, before I even send them a copy of the demand letter or whatever it is, I say, listen, I'm going to send you this, but you need to understand there's a little bit of gameplay here. This is a little bit of posturing. We're trying to gain leverage. We're trying to, puff up our side so it sounds really strong. So the other side gets maybe a little scared and wants to settle with us or something. So don't think that everything in this letter is 100% exactly as I say. Just that's part of the job of being your lawyer, being your advocate. This is advocacy. This is not necessarily my real analysis of the case. I have those conversations to this day with the people that I work with. And it's really important. You have to have those conversations more than once, usually. If you're good at your job and you've written something really compelling, you have to have those conversations before they see it and then after they see it again. So that's the next time I definitely would have that conversation. And then the next time I have again, like I said, this is a continuous conversation, continually managing their expectations throughout the engagement. The next time I typically would have that is right before we spend big money, before depositions are taken. Written discovery isn't quite as expensive. It can be, depending on how many documents you've got, but it's those depositions, especially depositions if you're going to videotape them or have an interpreter present. It triples the cost of them to have more and more people present in the room. And so depositions can be very expensive. And so before I spend the money on those, I have another talk with my clients. Okay, I need you to know what to expect here. It's going to cost this much money. If I'm on contingency, it's coming out of the costs are coming off the top of what you're going to get. It still affects how much you get out of the case. And if you're not a contingency, you're going to get a bill at the end of this month that's going to make your eyes cross, right? So they need to understand the finances, but they also then need to start talking about, this is when you talk about settlement with both sides, I think. And here's the conversation that I've had 1,000 times. I'm going to tell you how it goes, especially that I'm going to say I'm talking to my defense client, okay, which I represented more defendants than plaintiffs. I'm going to say, listen, if we keep doing all the things that you want us to do, you're going to depose all these people, file these motions, go to trial, you're going to pay me over $100,000. If we settle the case now, we might be able to settle it for $40,000. You save $60,000. And almost every time that client will say, I'd rather pay you than pay them. How many times have y'all heard that, right? Every time. And so I have to have that conversation many, many, many times before the client will, and hopefully they will finally just have a little come to Jesus moment, right? But for the most part, we have to have that. It doesn't work the first time. They have to see a bill. And then they'll go, oh, she wasn't kidding. Like this is going to be really expensive. And so at some point, I can usually get them to say, okay, you're right. I don't want to pay any more legal fees. Let's just pay them. But it takes a while, but you have to have the conversation a lot with clients. It's not fun. They hate to hear it. They get very angry because they don't want to pay that guy that guy did them wrong, but at some point the finances usually do eclipse the emotion when they start seeing legal bills, you know. So I have that conversation many times before we spend big money. After discovery is closed, obviously we have it again because that's when we're talking about filing a motion for summary judgment, maybe, which is not a cheap motion to file. Or we're preparing for mediation at that point or arbitration. That's when I think preparing for ADR is when clients really need to have their expectations on the process and the timeline more managed. Then at that point they spend a ton of money, right? Or they, or they're on contingency. So at that point it becomes what to expect. And a lot of people don't understand what mediation and arbitration do. They're very different, right? Very different processes. And so we talk a lot about in mediation trying to get some pre-settlement discussions between the parties because the purpose of mediation is to settle the case. And if we're not going to settle the case or we're millions of dollars apart, then mediation is maybe not going to work. So we got to get a little closer. And so we really have to have conversations when it comes to before we go into a motion for summary judgment or an arbitration or mediation as to what to expect from that. Motions for summary judgment are so much harder to win than people think. I myself, we use outside counsel for like slip and fall cases at California Pizza Kitchen. And a lot of times outside counsel will say, oh, we'll just file a motion for summary judgment on that. I'm like, what? It's a fact dispute. Why are we wasting money on that? I'm sure I annoy the heck out of them, but they're not automatically things that win. They're hard, they're expensive, and they're difficult to win sometimes. So, and then, obviously you go to trial, you're going to have a lot of conversations about costs and expectations for trial too, because there's no case that's a slam dunk. In fact, of the jury cases that I've had, I've won all of them, but sometimes not nearly as much as my clients were hoping to win. And at the same time, when I reflect on the cases, like one case, the jury came back and awarded my clients like $600. They had spent way more than that on legal fees. And I reflected on the case and I talked to the jurors afterwards and I knew that was the right result. I knew it was. And my clients just didn't want to listen to me. I was also much younger of attorney then and didn't have enough experience to understand what to really expect myself. So I probably didn't manage those clients very well. And it was not a very satisfactory result, even though we won, right? Even though I chalk it up as a W. So that's kind of my overview on managing client expectations. Really, the key is being really fair and honest and detached and objective with your clients, not taking on their emotion, not taking on their frustrations, their biases, communicating with them often and transparently. The more often you can communicate with your clients about what's going on, the more comfortable they're going to feel with you. And make it clear that you are here to assess their case objectively without carrying their baggage. And you kind of keep reminding them, you can't think about this emotionally or personally, especially if you're a business person. That can't be part of this. This has to be what's best for the business. And often that's just a financial decision. And so hopefully if you do those things, then your client will trust you.
Okay. May I ask a few questions?
Of course.
Okay. So Kendall, first of all, I assume that at California Pizza Kitchen throughout your career, you've been on the defense side of many different kinds of cases, many with consumer type plaintiffs, falls that you mentioned. And then there are business cases, could be anything from, you've probably had commercial lease disputes, you've probably had
contract disputes.
Contract disputes with vendors. Are there differences in the approach with different kinds of cases?
Definitely. If I'm representing an individual, which most of my cases were businesses or entrepreneurs, but an individual who owns their own business that's very different from the CEO of a company. The CEOs of companies that I've represented, even if they are emotional about the case, they ultimately understand that they have a fiduciary duty to their company to do what's in the best interest of the company. And so we can crunch numbers and figure out what that looks like. But individual business owners, entrepreneurs, and individuals who are in the case themselves, it's a lot more difficult. There's a lot more emotion involved. And interestingly, I actually have become friends with some of the individuals I've represented because I lean in on the counselor side of my job as much as the business side. With when I represent big businesses, I can really just be the business person that's in this situation. When you represent individuals, you really need to lean into the counselor part and really spend time talking about how they feel about the case and talking it through. There's a lot more of that. I'll tell you the most difficult client I ever had was a lawyer. I never represent lawyers again. Lawyers, I didn't represent him in a malpractice case. It was I want to say a contract dispute or a personal injury case, something like that. It was a long time ago. I don't even remember his name. But because and it wasn't his wheelhouse of law, but because he was a lawyer, he was so difficult. He just knew everything and tried to drive the case. And it was very hard to manage him as a client. The counselor part, the business part, neither of those worked, you know. But for most people, if you really lean into being a counselor and listening and spending time with your client to really understand how they feel and trying to draw out the personal emotions they feel about the case and kind of start tempering those, it's much easier to manage those expectations. I think that those are more difficult than the business people. Yeah.
Now, you also mentioned discussing settlement with your clients and how you sometimes have to do that over and over again and let it sink in. Let's look at a slightly different angle, and that is discussing settlement with your opponent, not client. Many people think that the initiation of a settlement conversation or a suggestion of a mediation is a sign of weakness. And some lawyers have some challenges with how to do that appropriately. What advice would you have?
I absolutely disagree with it's a sign of weakness. And in fact, I think if I know that I think the case should end up in settlement, those conversations are happening in the initial demand letters and responses. We are starting right from scratch. And I do that regardless of which side I'm on to kind of signal to the other side the ballpark that I'm looking at. I don't want them to come up with a $3 million demand when I was thinking $50,000. They need to understand right from the beginning what my ballpark is. Understanding that I'll never give away my final number, right, in the first couple of letters, but I want to establish where this is going to go. And that lets me drive the settlement discussion if I'm the one who establishes the ballpark. It doesn't always work that way, obviously. But I think you talk about settlement potential with opposing parties where you believe a settlement is the most likely or appropriate result, which is almost all the time, right? I think you start talking about those often with opposing counsel. I actually have a client that I had before I went in-house. So before 2017, I represented them for many, many things as a big business client. And they called me this past week and they said, Kendall, we need your help. And I said, I can't be on record in the court for you at all. I'm conflicted out. And they said, it's okay. We just don't like the way this case is going. We really think that this probably needs to settle. And we're not getting good advice that we like from our lawyer. And we just need you to help talk it through with us, help us figure out what to do. And I had started representing them in this a long time ago. And I said, well, let me just reach out to your opposing counsel and see where he is. And the opposing counsel said, I reached out to him. I said, hey, you remember me? I started, representing these guys before this all went to court. And he's like, I'm so glad you reached out because I've been trying to talk settlement with their attorneys multiple times and we've never gotten anywhere. And I said, oh, well, let's talk about settlement. I think sometimes it's very refreshing because most attorneys know that most civil cases should settle. Really, just financially, it just makes sense to settle instead of spend all the money on mediation, attorney's fees, and arbitration in court with the risk that you may not win, whichever side you're on. Sometimes it makes more sense not to. It's more fun to go to court, obviously, but for me anyway, I should say. But I think most attorneys are aware. The idea, though, I think your question is, sometimes opposing counsel needs to have their expectations managed too, not just your client, right? Yeah. And so that's where my discussion of establishing the ballpark comes in, that's where I kind of let them know, hey, this is around the area where this case is going to end up. And so that they know that they can't come in something crazy.
So how
And
do you
it
do
happens all the time.
So you get a demand letter and somebody says my case is worth a gazillion dollars
Mhm.
and here's why.
Happens all
And-
the time.
Right. And you think the case is uh, worth a relatively modest sum. What are the things you do to try to adjust the plaintiff's expectations where you think it's appropriate?
When I get those demand letters, and they look, we get them all the time, right? All the time. Especially wage and hour cases, the employer plaintiffs lawyers have, or employee plaintiffs lawyers have all kinds of crazy thoughts about what some of those are worth. In California, particularly difficult. But even slip and fall cases, we get them all the time. And so my legal team and I spend a lot of time investigating those cases if they come in with really big demands. A lot of time investigating to make sure we're not missing something that should warrant, a big settlement. I've never seen one yet that does. Let me tell you, but some of them, warrant something. And so we investigate a lot, and we tend to provide a response that's comprehensive, that offers specific dates, specific information. Sometimes we even offer documents that support our position to let the other attorney know that we've got evidence that shows that their valuation is not appropriate. If I just like with my clients, if you can provide actual tangible evidence to people to show what the reasonable expectations should be, that carries a lot more weight than just telling them, you know. So we send really, really comprehensive response letters to those kinds of demands.
Okay. Now let's focus in on mediations.
Mhm,
Assume that you've been involved in many of them over the
mhm.
years. What are the qualities of a good mediator?
A good mediator.
Yeah. What are the qualities of a good mediator?
I'm going to say the most effective mediators I've had are mediators that are pretty aggressive with both sides
Uh-huh.
and making them kind of aware of the valuation of their case and how they see it. Um, Sometimes I mean, I've been in mediations where the mediators come into the room with us and said, there's nothing I can do. I don't know what they're thinking. They have no reasonable expectations here. And this mediation really, I don't know that I'm going to get very far. That doesn't happen that often, but it's happened. I think I had one last year like that. I won several years ago when the very first offer that we made, the mediator came back and said they're leaving. So it was over right immediately. But for the most part, the mediators that make my clients really frustrated and make them feel like the mediator is working against them tend to be the best mediators, because I know they're doing that in the other room too.
Uh-huh.
And if and the old saying is the best result from mediation is a settlement where the plaintiffs didn't feel like that the plaintiffs feel they didn't get enough and the defendants felt like they paid too much. That's the perfect resolution, right? Where everybody's just a little unsatisfied. They feel like they had to give up too much. To me, I always leave those mediations going, they're the ones that will stick the best. That was a good mediator that came up with that. I really appreciate those mediators a lot. I don't say it in front of my clients, maybe, but I do appreciate the ones that really lean in to the clients, and really challenge their thought and really say, hey, if this went to court, this would happen and this would happen. I don't always agree, but I appreciate that they're doing that.
So you don't hide your client from the mediator.
No,
You together with your clients, and I presume your outside counsel, have conversations with the mediators together.
absolutely, 100%. And I'm a client in mediations now too, and I go to all the mediations too. Yeah.
So do you ever allow your client to speak to a mediator without you present?
But not without me present.
Uh-huh.
I have had mediators who've asked to speak to me without my client present, and that I don't like that. I think that creates a lot of paranoia in my client about what's going on, and am I colluding with the mediator now? I don't think that's correct. But I don't I don't think I would let my mediator talk to my client without me. It just depends on what they want to say. I feel like that's not appropriate.
Fair enough. So you've mentioned some mediations that are complete non-starters, and there
Yeah.
are a few like that. In those situations, how did you get to mediation in the first place? What made you sense that the time is right to mediate a case?
Um, the one that I'm thinking about from that just was recent, I think that was a court-ordered mediation, so we had to get there. The one a couple of years ago, several years ago, where the first offer we made, the other side got up and walked out because we made a lowball offer. We were the defendants, and they had millions of dollars in their head, and so they just left. I think in that case we hadn't established parameters going in. And I think that, like, I told you I could try to establish the ballpark. I do remember that I did establish a ballpark in that case, but the other side didn't tell me where they stood on that. Maybe they thought they were going to get away with something more with the use of the mediator. I don't know. But that was frustrating. That I want to say I've had impasses at mediations before, but they've gone many hours before you get to impasse. I think that's not an unsuccessful mediation because sometimes those cases will then settle. But one where somebody gets up and walks out right after the first offer, that was a failure on all of our parts. I think they didn't manage their client expectations very well, and the mediator maybe wasn't ready for that to happen. Or maybe my clients weren't prepared either. I don't, but I think that's the one only that I think, wow, that was just a real waste of time and money, because it was over so quickly.
I understand. What sort of due diligence do you do in selecting a mediator?
Um, Gosh, it's really hard to do that, but we read a lot of reviews, we read the background on the mediator or the arbitrator, we read representative cases that they've worked on and how those went down. The bigger the case, the more due diligence we do. Obviously, we are very, I'm going to say, wary of just taking whoever the other side proposes. You can imagine. And they should be for me too, because we're going to recommend people that we've had success with, obviously, on our side. So we try to find people who really are neutral. And then the last two arbitrations I've done for CPK, we've gone to a rank and strike because we haven't been able to agree on a mediator, but we've ended up okay in both of those.
Do you ever call a mediator on the phone and say, hey, the other side suggested you, can we chat for a few
No,
minutes?
I
No?
don't, I don't, I don't, I don't feel like that would be, I feel like that'd be like almost an ex parte communication with the judge, you know?
Oh, that's interesting.
No.
Of course, we do ex parte communications much of the day when we actually get to mediation.
Yeah, well, that's true. That's all it is, right? Yeah,
Sometimes
that's
that
true.
is all it is. Yes, yes. So I've seen California pizza kitchens in many parts of the country, whether
Mhm.
in airports or shopping malls and all over the place. Do you see regional differences in mediators? I assume you have disputes arise in different parts, different geographic territories. Are there regional differences?
Well, I've also practiced in Georgia, Florida, and California too,
Right.
as a lawyer before I went in-house. So, I I would not say I've seen regional differences. I mean, there's just a cultural difference between Georgia and California. Obviously, there's a much more genteel sort of hospitality, let's all be friends, good old boy kind of thing in Georgia that doesn't really exist in California. But I don't know that that necessarily translates to the mediator. I think it just is the mediator's temperament themselves and how they were trained in their approach to mediation. I'm trying to think of the last mediations I went to in Florida and Georgia, and they weren't remarkably different from California. I don't think.
How about closing techniques in mediation? Some people love mediators' proposals, some people hate them, some people love bracketing or simultaneous movements, some
Yeah.
people hate them. What what do you think are the best closing techniques in mediation when you're getting kind of close, but there's still a little territory to cover?
Yeah, it depends how close we are, the bracketing doesn't work well when you're still pretty far apart, I think. We have, I want to say at CPK in the last, we go to mediation a fair amount. We have an arbitration agreement with a mediation clause for our employees. So we're there quite a bit and we prefer it. the mediator's proposal has been successful in the last two times that was used in our mediations. It was a bitter pill to swallow both times because it's like I said, a successful resolution. The defendant pays more than they want. The plaintiff doesn't get as much as they want, right? But that's what the mediator's proposal almost always is, somewhere in that little sweet spot. And so it has been one that's not made us very comfortable, but it succeeded in the last two where that was used in the last, I think that's just in the last year. The bracketing, I'm meh about bracketing, but I don't, one of the things I also appreciate is a mediator who's like, okay, I'm not giving up on you guys. I'm going to come back and check in again in a week and, and see how things are going. That often is very helpful because once we've stepped away from the mediation and had a moment to sort of talk to our clients and debrief a little bit and rethink about the value of the case, maybe take another look at a new case budget, then the mediator coming back and facilitating that final discussion has been very helpful. I really appreciate that a lot.
So in the cases where you feel we're paying a little too much, maybe we should pay it anyway, what's the thought process that gets you to the point where you can live with paying a little too much?
There's two factors that we consider every time. And this is the conversation I have to have with my CEO when I go over my authorized limit. Factor number one is if we don't settle it for this amount, how much are we going to pay in attorney's fees and costs to go forward with the case? How much is it going to cost us? And look, we don't use the cheapest firms in town. I'm going to tell you, some of our attorneys are $1,600 an hour or more. They're very expensive. And so it doesn't take, nuisance value is not low, right, for us on those kinds of cases. So what is it going to cost us to move forward if we don't settle? And what is the probability of success here, which is impossible to really gauge, but we've been a lawyer for 29 years. You can kind of gauge it a little bit. Depends on the kind of case. And juries in California in particular, they love big verdicts, right? And so you kind of have to know how good is the die that you're rolling if you don't settle. And those two factors together, usually if we settle for more than we kind of had in mind going in, it's because of those two things.
Many mediators will comment, I've heard many mediators comment with respect to costs of defense, that when they raise the subject in a mediation, they get instant pushback. Oh, well, we don't consider that. It's from a different budget, or it's not, we're just here to talk about the merits. What are artful ways that you have seen mediators raise the subject of the costs of litigation or the costs of defense that brings it to you to the front of the agenda in a way that a little easier for you to accept?
It's always, I mean, I'm very budget conscious. And so it's always in my mind. And usually if we have outside counsel representing us, which we don't always do, and I'll address that, but the outside counsel, our outside counsel are very consistent in bringing that up because they know that for us to come back and use them again, their bill can't be $200,000. It has to be, it is sometimes, but it can't be outrageous or we'll find somebody cheaper next time. So they're often, reminding us about the cost of defense and the value, what nuisance value really means if we feel like it's a nuisance value case. But we also, I'm going to tell you, and so the mediator doesn't usually have to bring it up. Usually our attorneys will bring it up or we're just aware of it and thinking about it all the time. It doesn't offend me when the mediator brings that up because it's something that's top of mind for me anyway, as it should be. The only time that doesn't work is when we represent the company ourselves, which we increasingly have been doing. I have a legal team that has me and another person have a lot of litigation experience. And so as long as it's in a jurisdiction where we're licensed and it's not a big, super complex, out of our wheelhouse case, if it's an ERISA case, we're not going to touch it, but if it's a little case that we can handle, I mean, I'm on record with CPK in a case in federal district in Florida right now because I'm licensed in Florida and it's just a simple case, not that difficult of a case. It's just got diversity jurisdiction. So we've started increasingly representing ourselves. And when we do that, that line about attorney's fees cost doesn't work because we're already absorbing those costs. So that's I think that's one challenge for mediator when you have the in-house counsel who are representing the company itself.
Even though you are getting paid by the company and
Yeah,
presumably,
but I'm getting paid the same. The
you,
company's not paying me by the hour,
yes, but if you weren't working on this, you'd be working on something else.
undoubtedly, right? Undoubtedly, yeah. But that's difficult for that's not as easy as a argument as it is if we're paying outside counsel.
How about the argument that there's just a hassle factor, a distraction factor for executives? That's got to figure into it, and
Yeah.
yet it's very difficult to quantify. How do you deal
Yeah,
with it?
it is. You remember I talked about one case where I had to do sort of an intervention with one of the executives on our team. That was a big factor in that case. That about half of our executive team was going to have to be deposed in that case on very uncomfortable topics, and that was a big factor. There are other cases where not so many of the executives need to be pulled into it. And so it's not just local managers or whatever. And those aren't as big a deal, but certainly cases where half the executive team is implicated or at least needs to be deposed, or will be a witness. That is a factor. Of course, it's a factor. We're not here to be in a case. We're here to sell pizza. So
And the final question I want to raise with you,
okay.
Kendall, is thanks to the miracle of technology and Zoom, we're able to do these Will Work for Food, New Possibilities Hour webinars, and there are some mediations that take place on Zoom and some take place in person, some take place on other online platforms as well. Some arbitrations take place online, some in person. What's your view on employing these ADR processes online as contrasted with employing these processes in person?
I think since COVID, most of the mediations I've done have been online. And I don't mind that. A lot of depositions have been online. I don't love that. I like if I'm deposing somebody, I don't mind if it's my client who's being deposed, but if I'm deposing somebody, I like to look them in the eye. Same thing with trials and arbitrations. I like to have an in-person experience to get a good feel and read for the room. That makes a difference to me. Mediations, I don't mind being online. It's a different experience. When arbitration is like a trial, there's a performative element to it, that's important that you just doesn't convey on online like it does in person. And the only reason I like to depose people in person is because there's nuances that you observe when you're deposing someone in person. If they're writing notes to their lawyer, you can't see that necessarily on a Zoom, right? If they're need to take a break, if they're rolling their eyes at something, there's so much you can observe in person that you can't observe very well over a video conference. But mediations, I'm totally fine with. Most court hearings can be online, and that doesn't bother me. And I don't mind my clients being deposed on Zoom. I just don't want to do it myself the other way.
So what is it about mediations that makes it acceptable to do them online, whereas with some of these other things, you don't like that online?
To me, mediations are, I don't want to say they're lower stakes, but I think a mediator can be as effective on a screen as they can be in person. It depends on the mediator, if the mediator is an in-your-face kind of mediator, which I've seen work and I've seen backfire, but if they are, then in person actually is more effective. But I haven't seen one of those since we've been doing this in COVID. And so the mediations that I've seen online, I felt like they were just as effective. You have special waiting rooms where the mediator comes to meet you in your own room. It's just like you would do it in person. I haven't seen a reduction in effectiveness from this. And it certainly saves everybody a little bit of time and money.
On travel time, yes, it certainly can. Yeah. Okay, Jean, we're about out of time. Any final thoughts or comments or questions from you?
Oh, I loved it. Thank you. I'll tell you, when I was in practice and a mediator starts talking about cost of defense, I would just want to throttle them or just jump through the wall or something. It's like, stop that. That is not what's going to get the case settled. It would really be the reaction. My client already knows it. And don't you think I've told them? You
Yeah.
don't need to tell them.
Yeah.
So
Yeah.
anyway, thank you so much for being here.
My pleasure. This has been really fun.
Yes, Kendall, this was terrific. We not only got the barbecue chicken mediation with,
That's right.
with the smoked Gouda, the red onions and cilantro. You even threw a little pineapple in there, and
Oh, that's scandalous.
that made it superior. Do you want to give just another mention of the food bank to which you'd like people to?
Sure, thank you. It's Mariners Food Bank in Huntington Beach, California. It's affiliated with Mariners Church. And it's every other Saturday. And there's a long line of people who come in and get as much as they can take with them every other Saturday. I've worked there a couple times myself, and it's really rewarding. Thank you.
Beautiful. Mariners Food Bank,
Mhm.
Huntington Beach, California.
Yeah.
We'll put the link in the chat to make it easier for people to.
Thanks so much.
In a position to do so. Kendall Jones, thank you so much for your time. We really appreciate these insightful comments. Pleasure having you on the program.
Thank
Thank
you.
you. With that, we are complete.